You are rushing us. You are rushing us. So can I ask all the journalists to move out?
Ekiri mu kuba kigenda mu maaso obudde buno pulezidenti amaze okuba nga atuuka mu kkooti naye balema okugobawo abamawulire. Dr. Besigye naye butereevu aleeteddwa naye embeera nzibu nnyo nnyo nnyo. Kyalimu baganda babbi basubu ne bannyabo abali ku ssama e Uganda. Dokita olengera embeera gy'alimu mbi nnyo 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 nnyo. Waliwo breaking news endala gye tugenda okubatuusako mu maaso awo. Pulezidenti tuli naye Joel Ssenyonyi kwassa David Lubongoye butereevu mu kyali kusama Uganda mukenke ondeere.
Start with a 50% deposit bonus. Increase your investing power with Pocket.
Waliwo breaking news endala gye tugenda okubatuusako mu maaso awo. Pulezidenti tuli naye Joel Ssenyonyi kwassa David Lubongoye butereevu mu kyali kusama Uganda mukenke ondeere.
Start with a 50% deposit bonus. Increase your investing power with Pocket.
Waliwo breaking news endala gye tugenda okubatuusako mu maaso awo. Pulezidenti tuli naye Joel Ssenyonyi kwassa David Lubongoye butereevu mu kyali kusama Uganda mukenke ondeere.
Start with a 50% deposit bonus. Increase your investing power with.
And that's why I had wanted the journalists to first leave us so that we do some housekeeping. Because my friends from long time, they are somewhere in Egypt. Somewhere in have a feel of what they are. So let's say, unite.
Mukembera bwetyo bwere.
Let's move.
We shall overcome. We shall overcome. We shall overcome someday. In my heart, I do believe we shall overcome someday. 6 will die, 7 will die, 7 will die someday. In my heart, I do believe 7 will die someday. Bobi will cry, Bobi will cry, Bobi will cry someday. In my heart, I do believe Bobi will cry someday. And Bessie will live, Bessie will live, Bessie will live someday. In my heart, I do believe Bessie will live someday. Yes, justice will return. Justice will return someday. Deep in my heart, I do believe justice will return someday. Freedom for all for freedom, freedom for all for freedom, all for freedom, all for freedom, freedom for all for freedom, freedom for all.
Okay, Buteri omulungi ali ku Sama Uganda ekyo embeera bweri wano mu kooti pulezidenti aleetedde mu kooti badde baagala abamawulire kasabaganye okubanga bafuluma ekisenge kya kooti. Dr. Besigye afulumiziddwa mu bukuumi obw'amaanyi ennyo kw'ossa Dr. Haji Abed Lutale naye n'afulumizibwa mu bunkenke obw'amaanyi. Tulinawo breaking news endala egenda okuba nga erabikako butono nnyo omereeko simanyi lwaki temusharinga vidiyo mu mbeera erimu egenda mu maaso mu ggwanga obudde buno nga temusobola kubanga musharinga vidiyo ensi nejja neeraba ki ekirimu okubanga kigenda mu maaso. Tulina president Joel Ssenyonyi kw'ossa David Lewis Lubongoye tuli mu kooti etulirwamu wetuli obudde buno baganda bange abasibo ne bannyamuke bw'amaanyi nnyo ddala nga bwekiwulira oba nga bwenyiza okigamba abaganda bange basibo ne bannyabo mwenna abali ku Sama Uganda media. Waliwo breaking news tulina breaking news gye tugenda okuba nga tubawa mu budde butono nnyo ku kyekituuseewo ku poliisi kyekituuseewo ku poliisi ey'Ewandegeya tugenda kuba tubibawa masaawo sinza kukola breaking news eyo nga si president yagikoze naye nga kooti ewumuddemukko katono nnyo. Kooti ewumuddemu katono nnyo naye ate egenda kuba ekomawo mu budde butono balabe kyekiddako. Dr. Besigye afulumiziddwa mu bukuumi obw'amaanyi. So embeera bwetyo bweri abaganda bange basibo ne bannyabo mwenna abali ku mukutu ogwa Sama Uganda media to live ku Facebook kwetusinzira okuba nga tubaweereza. So bwekityo bwekiri abalungi abaliko. So basaba mwekumire bwekumize ku mukutu ogwa Sama Uganda media. Tulina press conference olwaleero nayo police sigenda kuwa mawulire gakanga for now naye ndowooza president waffe agenda kuba abyogerako. Bunkenke bukyali bw'amaanyi nnyo wabweru webunguluddwa buli kika kya byakwerinda baganda bange basibo ne bannyabo wabweru munda mu kooti madala ga kooti mu elevators za kooti na buli kimu bunkenke buli mu bweyongezi nga Dr. afulumiziddwamu katono nnyo ne Dr. Abed bafulumiziddwamu katono nnyo wetuli obunkenke bukyagendera ddala maaso. Abalamuzi nabo balaga nti bakomyewo Dr. akomezeddwawo. Mukyala wa Dr. Kizza Besigye obusika mukamabega katono nnyo. Mukyala Dr. Kizza Besigye amaze kubanga atuuka mu kooti wini byanyuma amaze kubanga atuuka mu kooti. Mukyala wa Dr. Kizza Besigye awene byanyuma amaze okubanga abuuzisa ku president naye amaze gagala kubanga gamuyitamu nakusindika nnyo gagala kubanga gamuyitamu. Basibo ne bannyabo mbasaba mweyongere okubanga mu sharing video please. Simanyi okola ki okuno nga toyinza kubanga okusharinga video. Simanyi ki kyokolako sofa ekinene nnyo okubigenda mu maaso tulayikinga tusharinga.
Allow me pass when I will pass the pass so that you can get space.
maama oyo yaddira maama waffe Jole Mugisha mu bigere naye waali okubanga balaba ensonga za retired Dr. Kanokiza Besigye nga bwe ziri mu kuba nga zigenda mu maaso. Aba FDC n'ebibiina ebyenjawulo bonna weebali okubanga ate tulaba ensonga za retired Dr. Kanokiza Besigye nga bwe ziri mu kuba nga zigenda mu maaso. Nga bwe mbadde mbannyonnyolako bwo obunkenke bususse, bwo obunkenke busukidde ddala wano ku kooti. Abesigye waali banaye temunsindika nnyo ensano eno kamera protectinga mukama wange so temunsindika eno teva ku Bobi please, temuvaako. Chairman Nyanzi, breaking news etuuseewo nayo tugenda kuba tugibagamba maaso awo. Chairman Nyanzi, all breaking news etuuseewo nayo egenda kuba ebaweebwa mu maaso awo. So bwekityo bwekiri mu kubanga essaawa yonna kooti ekwata omuliro, essaawa yonna kooti egenda kuba ekwata omuliro. Banaye pambe tugenda nyo maaso ga president. Maama tusigala wano bwetutya. Kamera ne protector president bambe tamusindika tena weeraga. Kamera teva ku president. Buterevu oli ku Sama Uganda Media beera bwetyo buli mu kubanga ate etambula wano mu kooti. Dr. Kiza Besigye waleeteddwa ne Dr. Abed Lutale bunkenke bw'amaanyi mu kisenge kya kooti kuba omuteeseza baganda bange bassebo ne bannyabo nga bwe mbannyonnyodde emabegaawo nti oli breaking news etuuseewo ku muganda waffe ssabakunzi wa Uganda ow'ekitiibwa Fred Nyanzi Sentamu so bampita Sama Uganda mwena mawulire wammwe top 10 okubanga mbaweereza ensonga za His Excellence Robert Kyagulanyi Sentamu era kamera eno eri official okumubeera maaso okubanga bawa ensonga nga bwe zitambula oba okubanga emuprotectinga mu buli mbeera. So bwekityo bwe kiri baganda bange bassebo ne bannyabo mu kisenge kya kooti. Dokita agenda kuba akomezebwawo mu budde butono nnyo. Dokita agenda kuba akomezebwawo mu budde butono nnyo. So tugenda kuba tubawa buli kigenda okubanga kigenda mu maaso. So okuyingira wano ababuuza security ya president okuyingira wano obadde bunkenke nga bwe mbagambye nti amagye geebongoludde kooti yonna tekibadde kyangu naye tubadde tulinafu okubeerako ku president nga kamera ye eriiso lye erisooka okubanga tuwa ensi ki kyennyini ekirimu okubanga kigenda mu maaso. So yensonga lwaki nti Sama Uganda mumulaba wano ne president ne baganda baffe abalala bali mu bitundu ebyenjawulo era ewali amawulire aga National Unity Platform ne baganda baffe abalala bali mu bitundu ebyenjawulo ewali amawulire aga National Unity Platform okubanga bagenda kuba babalaga biki ebiri mu kubanga begenda maaso. President kakasa wafulumira wano agenda kuba ababuulira kyekigenda okubanga kiddako. Teyatambudde yekka, yatambudde ne muganda waffe mukama waffe Alop oba leader of opposition ow'ekitiibwa Joel Ssenyonyi. President waffe aliraanye maama oyo mukyala wa Besigye gwe bayita Winnie Byanyima okuli ne secretary general w'ekibiina kyaffe ekya National Unity Platform owekitiibwa David Lewis Lubongoye be batambudde ne president okubanga babeerawo. Bwe ntunula mabegaawo omulungi ali ku ssama ndabawo eyali leader of opposition mu kibiina kya FDC omukyala okuva e Kasese Winnie Kiza naye waali n'abakulembeze ba FDC ab'enjawulo bwe bali NUP. President atugamba ebbanga lyonna tikyakulabirako y'ensonga lwaki nti ku mbeera egenda maaso president waali mukulembeze tayawulayawula mu bibiina tayawulayawula mu bantu kubanga bannayuganda y'ensonga lwaki nti omulaba waali president waffe omulungi taata essuubi lya Uganda His Excellency Robert Kyagulanyi Ssentamu y'ensonga lwaki nti mumulaba naye waali okubanga buli embeera egenda mu maaso abeerawo nga alaba kyekigenda mu maaso tonaku olwaleero era waliwo okusaba jasabikku ku kitebe kya NUP ebiriwo byonna tugenda kuba tubibawa baganda bange basebo ne banya mwekumire ku mikutu egy'enkyukakyuka megatta abantu okubanga tumanya ensonga nga bwe zigenda okubanga zigenda maaso baganda bange basebo ne banyabo mbebaza bwebaza mwenna abaliko abatumbudde mu nsi yonna gye musinzira okubanga kwe muli UK mbatumiddeko nnyo America mama waffe Latifa mutumiddeko nnyo atuyina mu UK mama waffe Madina mutumiddeko nnyo abaana bali Abu Dhabi abali Dubai abali mu Bahrain nammwe abali Sharjah abali South Africa abali wano e Uganda mwenna mbasamu ekitiibwa mwebale nnyo kubanga mugoberera ensonga z'enkyukakyuka mwebale nnyo okubanga mugoberera ensonga z'ensi yammwe kyemukola kya muwendo nnyo kyemukola kya kabi nnyo nkakasa nti mukoye gye muli mwagala kulaba kingi mu ggwanga lino musobola okudda ewaka kyetuliko baganda bange kyetuli mukolako tuyinza ffe okubanga tetuliiwo ne bwe munaba muzze tubasaba ensi yaffe mugizimbe kwekyo kyetuli mu kubanga tulwana baganda bange basebo ne bannyabo tuyinza okubanga ffe tetuliiwo kubigenda mu maaso tuyinza okubanga basajja batugyewo ne bambi tubasaba tufokasinge nnyo ku next generation tufokasinge nnyo ku baana abajja bagenda kubeera mu nsi efaananeta president ali mu kunyumyamu ne Winnie Byanyima mukyala wa Dr. Kanokyeza Besigye bambi tubasaba bwe tuba tetuliiwo mutuyambe nnyo okubanga muzimba ensi yaffe era nga bweri so bwekityo bwekiri baganda bange basebo ne bannyabo leyonda kamera beera ku president ono omwami y'omu kubajja kubateeka gavumenti ya Museveni ku bunkenke nga ayagala abantu ba bulijjo tebaddamu kubanga bawozesebwa mu kkooti z'amagye era n'asengaawo omusango so yoyo gulaba ali mu kuhaginga pulezidenti waffe obudde buno bwennyini oyo omwami bamuyita Michael Kabaziguruka era yali omubaka wa palamenti ow'Nakawa baganda bange abasebo ne bannyabo abali mu kugoberera ensonga nga bwe ziri mu kuba ate nga zitambula bamuyita Michael Kabaziguruka so bwekitibwe kiri oli ne top 10 Tata Kisolo Sama Uganda okubanga mbalaga ensonga nga bwe ziri mu kuba nga zitambula wano mu kooti Dr. Kizza Besigye waleeteddwa nga bagambeko emabegaawo bataata ne bamaama nti afulumiziddwa mu byokwerinda eby'amaanyi embeera gy'alimu nga eragira ddala nti si nnungi embeera gy'abaddemu ebadde eragira ddala nti si nnungi naye bamufulumiza mu byokwerinda eby'amaanyi naye agenda kuba ate nga akomawo kooti ewumudde mu buwummuzi naye dokita agenda kuba akomawo tulabe ki ekigenda okuba nga kigenda mu maaso baganda bange basebo ne bannyabo Michael Kabaziguruka ali mu kusaba president ku kanamba katono nnyo ali mu kusaba president kanamba era bwatyo akamuwadde akanamba so bwekitibwe kiri baganda bange basebo ne bannyabo bwetyo embeera bwerimu okubanga etambula omukutu oli ku sama oli ku mukutu ogwa sama Uganda media so bwetyo embeera bwerimu okubanga etambula baganda bange basebo ne bannyabo kooti ekomyewo Kooti ekomewo baganda bange abasifu ne bannyabo kooti
Pilot, on my part, I think 10 minutes is enough, and then my colleagues will also come. My Lord, it's our prayer that you will be pleased to find that Dr. Basazeko are very literate. In the incarceration, given the fact that, my Lord, there is no evidence before you that there is any charge further against them, or that there is any man warrant being issued by any court, or any lawful order given by court for the authorities in Louisiana to give them custody. My Lord, the affidavits which are borne out, the facts which are borne out in the affidavit of the Honorable Willie Yanima, as well as Counsel Prosper, are uncontroverted. There is no any evidence of the respondents that the Attorney General and the Commissioner General controverting that evidence. And in Section 57 of the Prisons Act, my Lord, in Section 57 is very clear. The Prisons Act can clearly specify the person shall not be received or admitted into prison custody without valid commitment or remand warrant or order of detention, warrant, conviction, or commitment. So that is the law, my Lord. And now, my Lord, the essence of habeas corpus is well explained in the decision of this honorable court in Seniors Code number 16 of 2021. Honorable Chakulani Sentamu Robert, Babula Chakulani Pungo, versus the Attorney General and the Chief of the Defense Forces. On page 14, my Lord, a copy of which is going to be supplied to the court. Section page 14, this honorable court had the occasion to succinctly explain the essence of the writ of habeas corpus in the following terms. The purpose for a writ of habeas corpus adverse proceedings is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prisoner or jail warden to continue holding the applicant. The application is used when a person is held without charges or is denied due process. Yes. My Lord, that is for the Attorney General and the Commissioner of Prisons to explain by way of evidence.
So for you, you have no idea.
My Lord, I will explain. My Lord, initially there were charges that had been preferred against them as explained in the affidavit of Willie Yanima and the proscopia for the here. My Lord, that is well explained. If I may go there, my Lord, to read a relevant paragraph. The explanation is that, my Lord, the defunct General Court Marshal had preferred charges against them. And on the 31st of January, my Lord, the Supreme Court unequivocally pronounced itself for the
Kiza yali yassibwa mu kooti maaso bwe yalesibwa emyaka 2 naye aleeteddwa mu kooti obudde buno omwami ey'okubayita Aaron Kiza. Aaron Kiza y'oyo naye aleeteddwa mu kooti y'amagye naye yali yamusalira emyaka 2 yenna empingo zimusaze emikono naye aleeteddwa mu kooti.
What happened, my Lord? All the proceedings before the General Court Martial were quashed by the Constitutional Court, and my Lord, the decree to that effect was extracted. My Lord, I'm sure it's on record, my Lord. Yes, my Lord, we can be granted more time from the deputy and because I don't want to adapt myself in this matter.
We have members of the media. It is very important for them to hear what the Supreme Court says.
My Lord, it is hereby ordered that the declaration of the Constitutional Court that Section 119, subsection 1G, now Section 117 of the UPDF Act, which provides that any person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense is unconstitutional. So that order is hereby set aside.
Now, in one line, what is that paragraph?
My Lord, initially the Constitutional Court had held that Section 119, which is now 117, that had provided for a situation where civilians would be subject to military law if they abated the commission of an offense by a serving officer, that was a valid law. They have not nullified those provisions. Now, that order of the Constitutional Court was set aside by the Supreme Court, meaning that Section 117 has now been nullified by the Constitutional Court. All charges, all ongoing criminal trials, all pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. Yes. All charges, my Lord, all charges, these charges are preferred by the DPP under Section 120 of the Constitution. The charges before the General Court Martial are not sanctioned by the DPP. So the charges to be taken or transferred to the civilian courts pursuant to this particular order are those ones sanctioned by the DPP. As we speak right now, there is none, my Lord. There is no charge sanctioned by the DPP to be taken to the civilian court.
So, but in this sense, the decree indicates that there is a certain court, not the civil court, not the civil thing. Is that how I understand it?
That they are coming, yes, my Lord, a court of competent jurisdiction.
So, address us very briefly when I am a court of competent jurisdiction.
In regards to taking fully, this is not a court of competence. But in regards to the matters before you, habeas corpus addis abducienda, we are in the right forum, my Lord. Yes. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in the court of law. And this is not applicable to the applicants because they are not convicts. And finally, my Lord, no, the second last one. All pending trials, all partly hard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. It's also not applicable. It's for the serving members of UPDF. 5. Save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. That is
So, very briefly, how many paragraphs are applicable in the motion before this court?
my Lord.
Under that thing?
As far as the matter before you is concerned, it's paragraph 1. Only paragraph 1. Where,
Focus on that.
all right, my Lord. My Lord, the submission is that following this declaration of pronouncement by the Supreme Court, the proceedings hitherto pending before the General Court Martial under Section 117 of the UPDF Act became inactive. They were quashed, and there are no proceedings pending against the accused person. And that brings us within the realm of the prerogative order of the writ of habeas corpus. We have already cited Section 57 of the Prisons Act, and also now the Section 38 of the Judicature Act. But now we are addressing here on the issue of curtailment of liberty and the remedy that court is enjoying.
Do you intend to make written submission?
No, my Lord, we are given the nature of this matter, my Lord, and the circumstances concerning the dire state of our client, particularly Dr. Elizabeth, his health status. We deemed it imperative that my Lord.
At least I can go on with what was being thrown around the media. There seems to be any we order. Okay. For me, I'm revealing prayer. That what has been written about status is a bit. 1 minute, the Lord Mayor.
3 minutes, my Lord. Most of that, my Lord. My Lord, I've already addressed you on the question of liberty under the authority of Chapter in the Capital Jingo. One aspect which I needed to point out in this factor is still on page 14. Liberty is defined by Black Law Dictionary. Freedom from arbitrary or undue external restraint, especially by government. And this is, my Lord, the import of the spirit of Article 23 of the Constitution, which guarantees the liberty of Dr. Elizabeth and Obedi Mutare. In this particular case, my Lord, under Article 23, first of all, they have not been informed of any offense under which they are, which they may have committed, and the reason why they are in New Zealand, and there is none. 2, my Lord, Dr. Besige has no access to a personal doctor right now for proper medical examination. And that is a very serious matter, my Lord, because in as much as by a cursory look here, court can make one observation that maybe it's improving. My Lord, his state, the circumstances compare that an order be issued for Dr. Besige to regain his liberty, to be able to access a medical facility of his choice, so that he can be thoroughly examined to assess his health situation and get proper specialized treatment. My Lord, the final authority I would like to cite on this one is Tuanika John and others versus the Director General of the Internal Security Organization. It's miscellaneous cause number 9 of 2021, where again this honorable court resolved and decided that a writ of habeas corpus applies in cases of illegal detention and is meant to secure the personal liberty of a person under such illegal detention upon determination of the validity of such detention by the court granting the writ. I agree with the counsel for the applicant that preservation of personal liberty is crucial and should only be derogated from in exceptional circumstances where there are court orders. And that is the position of the law. So this particular law, my lord, is reinforced by section 15 of the Human Rights Enforcement Act. My lord, and this is where we are grounding our prayer. Section 15 of the Human Rights Enforcement Act of 2019.
Let me to share some information with you. There is a separate application grounded on the enforcement of human rights by a number of lawyers, and that file is before another judge.
Most of that. Let me not go there, my lord. Let me sum up, my lord, my submission under section 38. My lord, it's our humble prayer. Now that the Attorney General and the Commissioner General have not in any way attempted to justify the incarceration of Dr. Kizabesi and Bobi, my lord, you be pleased to order for their unconditional release, and specifically for Dr. Kizabesi to be able to access a medical facility of his choice so that he can be attended to by physicians of his choice.
Yesterday, should make that order now.
Yes, this is the prayer, my lord, that the order be made today and now, under the circumstances. And that's what the legal habeas corpus is all about. Any continued detention, my lord, would be again further violation. And we wouldn't want to see this honorable court acquiescing in the violation of the rights of the accused person. And one thing I need to emphasize, my lord, is the 48-hour rule, which is very, very crucial and imperative under the Bill of Rights. So you can only curtail one liberty within that period of only 48 hours. And to date, since 31st, Dr. Bobi have not been taken any fresh charges whatsoever. So we pray that, my lord, you be pleased to invoke the powers here, grant the prerogative writs, and have Dr. Bobi and Bobi released. We do so, my lord.
Like I said, it's my former counsel. We are trying to be nice.
Hello, maybe just make very simple. It appears that this breach matter before you is being constructed around the decision. But before we even arrive at the decision, I think there are two simple points that must be made. Personal liberty can only be curtailed on the basis of some lawful order. That lawful order cannot be verbal. It must be documented. It must be demonstrable. Otherwise, the curtailment of that liberty is unlawful. And because of that problem, the unlawfulness, and that's why we have this writ in Article 54 as non-derogable. But it has two limbs. One has been satisfied. And perhaps the most common one that has been satisfied is that the person has appeared here. But like in Gira's case, it was known where Grace Gira was being kept. It wasn't the case of, the common thing that was disappeared. It was known where he was. Just like it is known where his applicants are. In fact, we did not say much because when they came here, they were in the company of other officers of the state who have a unique attitude. So we were able to tell that they are in custody. We knew where they were. So That means bring the body. Sometimes we wait whether dead or alive. The body is alive. Yeah. But the second thing, what my landlord has been addressing the court for, the reason for curtailing the liberty of those people. My Lord, the Supreme Court did not say that those who are incarcerated should remain incarcerated, except for those who had been convicted. One might argue,
For example, you are thinking we needed to consolidate these two applications. So you are saying for our friend Edwin Kisa, since he was convicted, so
that case is actually difficult, and you will note when it comes up. Those who have been convicted, unless they are not challenged the conviction, I believe my land friend is very vigorous. So there is nowhere in the judgment where it was said those who are in detention stay there until such a time that the government decides that to find a competent court and transfer those files. So this application is brought with that idea, my Lord, with that argument in mind.
I wish we can get a chair for the AG staff. They need to write some of the things. They have to write supposed to be a lawyer like you.
I'm not among the concerned in the statement. Private lawyer. Private lawyer. Were you officer?
I apologize. The officer of the court.
So my Lord, one of the orders that was made is that these trials cease and be transferred. In there, they could have added, cease, the detainees remain in custody until the cases are transferred. They did not do so, and they were wise not to do so, because they had just pronounced themselves on the illegality of the basis of those charges before the court martial. So, my Lord, as we speak, there are no charges pending anywhere in Uganda or elsewhere, apart from a case in Buganda Road on which the first applicant is on bail. His bail is being extended, but he goes back to another location. That is the only one that is paid. But in that one, his liberty was given back into him. My Lord, the burden to justify the reason for detention, for containing person, is not on the one who is applying. My Lord, you can see that the affidavit was not even sworn by the one applying. The burden is not on the one applying. The burden is on the state.
And the state has
The state has implied, I'm going to address what it says. There are two aspects involving the state, two bases where the state is responsible. in my view. One, the prisons officer would have brought before this court a warrant saying Court X on date Y told us to keep the body of these individuals until we go back. I have not seen it in the response. The second possibility would have been that they are pending charges, and this is the charge sheet. I know those pending charges can't come from the court martial. Because some of the offences in the UPDS can't be tried in the civilian courts. There are offences there that are very different, of a very different character, and they don't exist in the penal code. They can't be tried in these normal civilian courts. So they would have brought a charge which says, you in court X, they are pending charges. This is the reason why these people are. What do they refer to? They refer to the Supreme Court decision, which did not say keep them in court.
Maybe it's the edging.
So I want to submit, my Lord, and I hope that you will be persuaded that the response from the Attorney General falls short of justifying the reason for denying the applicants their personal liberty. Since the 31st of January 2026, it says nothing to you, my Lord, that explains why the liberty is curtailed. It only says the Supreme Court said transfer. But as I have shown you, some of these offences cannot be transferred. But that may not be a matter for us to address it. But they can't be transferred. So it is our contention, my Lord, that a proper case has been laid out by the applicants to this court, which is clothed with that power. Not the power is unfettered. It is so unfettered it can be applied immediately. Clothed with the power to order the release of these applicants today. If the state has a lawful reason, let it act lawfully after those orders to then deal with the issue, whatever the issue is. Lord, my young friend has made reference to section 15 of the Human Rights Enforcement Act. I am aware, my Lord, you are perfectly familiar with that space, and I very respectfully urge you, my Lord, to find merit in this application and to grant the orders that are being sought. My Lord, my young friend, Honorable Sekona, you want to just wrap it up?
How many minutes?
My Lord, I will request for only 2 minutes. Except that I will request that your office are obstructing your view of my body language. You are told that you need to look at me. My Lord, just to sum up, Section 57, which has been cited by my Lord friend, Honorable Elias Lubongoye, is instructive. A prison's officer can only detain on a valid warrant issued by a competent authority, in this case, court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application. Whereas it is argued by the first respondent in the affidavit of Mr. George Kalemera, paragraph 9, that the Supreme Court did not order release, there was actually no necessity to order release.
So, yeah, on that point,
Yes, my lord.
so you are trying to read in some words in the decree.
No, my lord.
It is saying it was not necessary, but it said so many words.
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on an order, on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my lord, and duty to order freedom to be reinstated. Away from the Prisons Act, my lord.
Okay, because some people, the Lord Mayor, the former teacher, are putting me under some points that I should read now. But I need to write it. How do I write it?
My lord?
Can you address them?
Yes.
I can write it.
Yes, my lord.
Hours.
Yes, my lord, now is contextual. And what we are saying by now is that upon conclusion of our submission, the court be pleased to begin writing the release order. In the same realm of context, my lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been misconstrued. My lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court did not order the Director of Public Prosecutions to take over, because that is barred by the Constitution, Article 120. In effect, the Supreme Court told the first respondent, if he's interested in any prosecution, to go and start de novo. Do a fresh investigation, a fresh complaint. What one would expect is the state to report to the nearest police station or post and report and to start with first information. Why? Because any warrant of court has an expiry date and tenure. My lord, with your permission, and I'm grateful, because the DPP cannot take over, the transfer order must be contextualized to mean, if you are interested, start a fresh complaint system. Go to the nearest police, report that these people are alleged to have committed offenses X. And when you do that, the DPP looks at the file, because the DPP even has the power to say, this one does not merit, and drop it at that stage. I was taking you on the point that a warrant or detention order itself has a time limit. Bring back this person on this particular date. That is axiomatic. And the moment it expires, lawfulness ceases. In this particular case, warrant of the defunct court martial was actually in itself expiring on the 3rd day of February. They could not extend or even terminate because they had ceased to exist. And since that time, the lawfulness, if at least it had not collapsed on the 31st day of January, died or redied on 3rd. My Lord, to contextualize Act 120 and the decision of the Supreme Court, I would implore you, and we shall supply a copy, the decision of the East African Court of Appeal in Kagenyi versus Musiramo and another. Kagenyi versus Musiramo and another. 1968 East Africa, page 43. The gist is this: that a transfer is not even possible if the court originally had no jurisdiction. The decision of the Supreme Court, or even the Constitutional Court before, are to the effect that from the word go, the General Court Martial had no power, had no jurisdiction. So there was nothing to transfer. That's why I want you to contextualize the decision of the Supreme Court. Finally, my Lord, on the question you did ask me, when we say that you be pleased to order now